you had a wonderful weekend. Hello, are you guys hearing me?
Yes, I will try.
Okay, then. It's good to have you back. The last lecture, we started on law and morality. And you recall the two scenarios I painted. And of course, before we left, we gave an assignment of a sort, which I wasn't expecting anybody to submit, but which I expected everybody to have undertaken. And it relates to two different cases. One, Shaw versus DPP, and the article case. How many of us read the two cases? I appreciate the fact that you must have come across Shaw and DPP earlier in your studies, especially under criminal law. And I also expect that somehow in your constitutional law, you must have come across the article case. I want to assume that all of us read the two cases. So can we have a brief gist of the cases and the centrality of the decisions in the two cases as it affects our current engagement of law and morality? Is anybody willing to start off for us?
Good morning, sir.
Good morning, Tomakwe.
Yes, sir. So on the case of DPR, Shaw against DPP, it has to do with a man who was featuring the adverts of prostitutes in his magazines. And he was promoting these prostitutes, and he was getting a particular percentage from their earnings. And the states, feeling that he has committed an offense, especially breaching the provision of certain prostitution prohibiting acts and other laws like that,
Okay,
charged him before the court for, among other things, for corrupting the public morals. In the trial court found him guilty, and the defendants, now appellants, appealed to the Court of Appeal, and the decision of the court was upheld on the basis that the state has the responsibility of ensuring that the morals of the society is not corrupted. So basically, the decision of the court was based on public morality.
okay. Thank you, Shomakwe. Yes, that appears to have represented the decision. So, Shomakwe, in your own view, the decision of the appellate court was essentially that Shaw had corrupted public morality, I guess?
Yes, sir.
Okay. Yes, thank you, Shomakwe. Can we have a gist of the other case? Can somebody give us a gist of the other case? Hello? Are you hearing me?
Yes, sir.
Yes.
No, you are not the only person in class now, Abroshid. Or is only Abroshid that is in class? I can see that we have 34 others. Huh?
We are here, sir.
You are not here.
Yes.
You are not answering questions. The only way to show that you are here is for you to answer questions. Well, I want to assume that we already have the gist of the two cases, and then we go further. Because as you lay your bed, you lie on it. Oh. So essentially what law and morality represented and the essence of calling attention to the two cases is that it appears that the two cases were deciding on the issue of law and morality differently. Why one is emphasizing the essence of morality, the other appears to be emphasizing the need for us to underplay morality. Well, my position is that the two cases appear diametrically opposed to itself in terms of their decisions, but a proper look at the decisions will give us a different opinion. And I think I will just stop at that, except that I call attention to two critical quotes from those decisions. I will assume that if you have not read it, you will take your time to go and read it now. Like I said the other time, I'm giving the scenario, the two scenarios I painted in class when we started the discussion on law and morality, that law and morality are viewed by scholars from two different perspectives. The first perspective is, oh, there cannot be law without morality, and therefore law and morality is just a coin with two different pictures, one depicting law, one depicting morality. The other view is that there's no meeting point between law and morality, and that if the two concepts are different from themselves, then we cannot be talking about any correlation, that there's no meeting point for the two of them. In fact, Hans Kelsen, in his argument of the pure theory of the law, which I am sure you must have either come across or you come across later in the course of the study of jurisprudence, talked about the fact that when we talk about law, we are talking about attachment of sanction. And that when we talk about morality, we are only calling for moral adjuration of the people concerned. But I am not sure that it is that sharp in its division in terms of one is sanction, one is no sanction. Therefore, any law that has sanction is law, anyone that has. And we go back to our initial scenario. If my child refuses to greet me and I refuse to give him transport fare, is that not a sanction? And if I now say, oh, you have decided not to greet me this morning, and I have a right to keep my own money too, that's a sanction in a way, but not the kind of sanction that law emphasizes. And in the traditional African setting, if there are some moral codes that are regarded as no-go area, for instance, talking about I have thought about societies where adultery is permissible, encouraged, and practically endorsed. There are societies or communities where the society frowns at things like this. And there are traditional sanctions, as it were. So the point we are making is that the kind of division that Hans Kelsen is trying to provide for the distinction between law and morality appears not to be valid as far as traditional African society is concerned. And indeed, in practically all society, the sanctions may not be as effective. The sanctions may not be the kind of punishment, go to jail and pay fine, that we may come across with regards to other the other side of law that we are talking about. Are we together?
Yes, sir.
Yes, sir.
Yes.
Yes, sir.
Good. Now, one other feature, we have talked about sanction. One other feature that has been put in place with regards to relationship between law and morality, apart from sanction, is that, the totality of the focus of morality is to appeal to the conscience of the individuals in that community to do that which is right. Identify what is, whereas law will identify what is wrong and apportion a punishment. That is, if it is morality, we will only appeal to conscience. You know, this is not good. You know that if you do this, you will be polluting yourself, you'll be polluting the society. And it is important for us as human beings not to pollute the society, to ensure that society progresses and all like that. But with regards to law, don't do this. Doing this is wrong. Don't steal, don't commit adultery, don't do this, don't do that. If you do this, this is the punishment. If you steal, 7 years. If you commit rape, 14 years. If it is manslaughter, it is life imprisonment. If it is murder, it is death. This appears to be another feature with which we distinguish, but it will be, in my view, be wrong to believe that appealing to conscience has no role, has no place in law. No, because if you look at the psychology of law itself, if you look at the way law evolves, of course, I will come to that again as another distinguishing feature between law and morality. You will discover that essentially identifying what is wrong is not the initial focus of the law and apportion punishment, but rather appeal to conscience as to what is right. And for me, it is important to emphasize that the fact that we are no longer putting premium on the appealing to conscience of the individuals within the society has created ineffective laws in our society, because it means that we are not factoring the social issues into our operations. And for as long as we make it look mechanical, that this is law, obey it, then we will not get the appropriate result that law is supposed to provide in society. And what is that appropriate result? Peace, order, good governance. And that is why, in my view, we are not getting it right. For instance, let me call attention. You can see the trajectory of Obamacare in the United States of America as against Petroleum Industry Act in Nigeria. For those of us that followed through the challenges that Obama had in putting Obamacare in place, he had to lobby, plead with the Congress to support the position. By the time Donald Trump became president, the law suffered a lot of hiccups, but somehow it's back in a more effective manner with the emergence of Joe Biden. But if you now look at the travels, the challenges that petroleum industry had in Nigeria, and the eventual passage and the possible effect of the act in Nigeria, you will agree with me that a law that is not targeting the conscience of the individuals may not effectively be law indeed. And of course, what that means is that dividing law and morality from the perspective of identifying what is right and appealing to people to do what is right, as well as identifying what is wrong and apportioning punishment as a feature of a distinction between law and morality, is a broad division. Are we together?
Yes, sir.
Yes, sir.
Yes, sir.
Any questions so far? Any questions so far?
No, sir.
Yes, sir.
Okay.
In essence, are we saying that there is a fine line between the division or between the distinction between law and morality? Because what it actually comes to is that there is no distinction really, because we are still saying that in law we still find laws that appeal to human nature. We still talk about the fact that deviation from sanction is not also a fine line. So are we saying that there is really no difference between the two, sir?
Well, I have told you at the commencement of this class that there are two views with regards to the relationship between law and morality. And the view that appeals to me is the one that says law and morality represents a coin with different pictures. And the view that does not appeal to me is that law and morality have no meeting points. And that's why I call attention to those that believe that there are two different streams that do not and may never meet. They are parallel. I've argued that, the argument is, one, there is a rule of sanction, is a rule of appealing to conscience. It's sanction, no sanction. Conscience, identify what is right and appeal for what is right to do it, as well as identify what is wrong and punish what is wrong that has been infringed upon. I am saying this demarcation cannot be strictly followed, but that is not to say that the other side of the divide that believes that there are different streams and may never meet, not also looking at the thing in details. By the time you look, you read deeply about the positions of those that are saying there are two different streams and they never meet, and that's why they will say law has no basis in morality. And if you read the decision of Aderemi GSC as he then was in Atiku's case, you are likely to come to that conclusion that, oh, it is law has no basis with morality. So for me, the two views, the two scholastic dispositions still exist. But in spite of their existence, our role is to interrogate the rationale behind the two decisions. The two positions, as it were.
Thank you, sir.
Okay. Now, I don't know. Adaramola also raised an issue with regards to the relationship. And he came up with what he called the fact that morality is essentially persuasive, while law is also about punishment. His argument was far more extensive, and there's also the rationale of evolutionary and revolutionary approach, that morality is essentially evolutionary, while law is revolutionary. And my argument is there is no way law will be put in place in terms of, oh, this is the law, obey it, and you are sanctioned. And my usual example is the Okada regulation in Lagos. When Fashola started it, without factoring the economic implication into place, when El-Rufai came up with his own in Abuja, without factoring the economy into it, the law were actually obeyed in breach. Whereas if law had been revolutionary, we can only be talking about edicts and decrees as laws that are revolutionary. All laws in democratic societies are evolutionary the way they think morality is evolutionary. I don't know where, are we together?
Yes, sir.
So the point I'm making is that the division or the distinction that law is revolutionary and morality is evolutionary is also a distinction that, for me, is not valid, and which will mean that we are still on that point that law and morality is still a coin with two pictures. And if you look at the trajectory of Petroleum Industry Act again, you will agree with me that whether we like it or not, a law that targets us at being a revolution will not have a place in a democratic setting, but maybe in a military setting that we had, because the military head of state will wake up one day and say, don't do this, and it becomes law. That is not the situation in Nigeria. For instance, our legislators put in place a number of bills that never saw the light of the day. Not because they didn't have the process in place to pass the laws, but because somehow, by the time the public hearing comes on board, look at the Electoral Act now. what was the problem with the issue of electronic transmission of results? If it is left to the National Assembly, it's as good as dead in terms of electronic transmission of results. But today, caution has been applied, and I guess that's why we are still tinkering with it, and we are yet to have it as a law, as it were. So to now create the distinction of law and morality being distinguished from the perspective of evolution and revolution is because a law, in my view, will start as a moral code and then generate, graduate to becoming law. So there is that evolution too with regards to law, because it will start from the perspective of this is wrong before it gets to the need to create a sanction. Are we together? Hello?
Yes.
Yes, sir.
Yes, sir.
Okay,
Yes, sir.
just to be sure that some people are not just online sleeping. And say, when he finish, you will see, he will go now. Don't be so.
Not at
None
all,
of our
sir.
students do
Not,
that, sir.
not at all.
Not at all, sir.
None of our students.
You say what?
Wow.
I said, no, I trust our students, sir.
Oh, thank you, Prof. So let me join you in trusting them. Now, because I said this, I asked them to do something for me. They refused to do it except Abloshid. Even Abloshid is only ratio and DPP. Okay, Professor Kantorowicz. Kantorowicz is spelled K-A-N-T-O-R-O-W-I-C-Z. K-N-K-A-N-T-O-R-O-W-I-C-Z. Kantorowicz came up with what he called the vision of rules as a way to provide an understanding for our understanding the relationship between law and morality. And he came up with 3 rules. One, he called command. The second, he called dogma. And the third, he called precept. So Professor Kantorowicz divides rules into 3 segments. 1, command, 2, dogma, and 3, precepts.
Sir, please, can you spell the dogma?
D-O-G-M-A.
Is the third one precept?
Precept. Precept. P-R-E-C-E-P-T.
Okay, sir.
And the said command is a rule that is obeyed the way it is put forward. For instance, electoral act had been put in place. If you are not 18 years, you are not eligible to vote. If you are not 30 years, you cannot be president of Nigeria. If you are not 60 years, you cannot be governor of a state. If you are not 80 years, you cannot be chairman of a local government. That's the dogma, and it has to be obeyed the way it is put in place. But that's command. No, command. And that with dogma, we obey because it's reasonable. It tallies with logic. We must not steal. You think that, okay, stealing is bad because I'm taking away something from somebody, something that does not belong to me. I am appropriating it to myself. It's dogma. It tallies with reason. But this is also not, let me tell us the third one so that I will now be able to, one, just oppose the way Kantorowicz has just opposed, then come up with my own view. And the third one is, we obey because it is good. That is the precept. Command, obey that is put forward. Dogma, we obey because it is logical, it is reasonable, and precept, we obey because it is good. Now, I have given the example of the Electoral Act as the law that is put in place, you have to obey. The law about theft is also a command, as it were, and most laws actually belong to that regime. That is, as put forward, you have to obey. That is what, as far as Kantorowicz is concerned, what law represents. And morality now represented by precept because it is good. Don't take another man's wife. It is good, though. Will create some crisis in the society. Therefore, you feel obliged to obey it. And that is the rule of morality. And that the one that is talking about logic and reason is just in between the two divides. It is good to obey, it is morality. You must obey, it is command. And that is the law. But I'm also saying that there is the division as created by Kantorowicz is also not as sharp as he wants us to believe, because especially the last two, dogma and people who obey, who have to obey laws, whether it is logical, whether it is illogical, whether same-sex marriage, for instance. If you ask somebody that is either bisexual, or the homosexual, or what's the other one now? By their own biology, the law is not good. And that is where the issue of morality and law conflict. The law is law. The people that are championing stuff have argued that the natural composition of this set of quote unquote
The service is breaking.
Are different from the normal. Yes, they told me that my internet connection is unstable. I guess it's back. Hello.
Yeah, we are with us. Is back now.
It's okay now.
Is back now. Thank God. Oh, thank God. It's good to be back. So the point I'm making is that the command, dogma, and precept classification by Kantorowicz is that command is the law and precept is morality. And between the two, we now have dogma. Any problem?
So your internet is still breaking, sir.
Even now?
Yes, sir.
Hello? It's still not clear.
It's okay now.
It's clear, sir.
Well, you have to beg TN, beg Glow, beg. So maybe we will suffer for. So the point is not as clear, and that's why I'm explaining that yes, electoral act as far as Kantorowicz is concerned, that is law, and you have to obey it is put forward. If you have somebody that is 16, that looks matured, will register to rule of morality as far as Kantorowicz is concerned. We are saying, for instance, that one that we say is good and is a rule of morality is also a function of circumstances. And that's why I came up with same-sex marriage. People with biological disposition to have affair with same-sex will see the law as not good. And the idea of morality will not have a place. It will still be a law as far as they are concerned. It will still be a law for them that is put forward, and you have to obey it the way it is put forward, not a matter of whether it is good or bad. And don't forget, in our definition of, in talking about definition, we talk about good law. And we are talking about good law from perspective of different status and standing in the society. As legislator, what is a good law? As a policeman, what is a good law? So a law that is good, that is being obeyed, and as a law, as a rule of morality, will not have a place in this kind of argument, in our view. I hope we are together.
Yes, sir. Yes, sir. Yes, sir.
That's my own position to Kantorowicz. Do we have any contrary view? And I will expect contrary views, of course, which will make the work a lot more challenging. Yes?
Yes, sir.
Mohammed.
Yes, sir. I don't have a contrary view, sir, but I want to seek your indulgence to let hear your view again, because it seems the network was bad when you were saying it. Apologies, sir.
Àìtorí àròjàre kí tọ́ tán lẹ́nu. Ṣé ẹ gbọ́ Yorùbá yẹn?
Bẹ́ẹ̀ni, sir.
Okay. So what does it mean? Thank you, Jare. Now, we identify the three components that Kantorowicz divided rules in his own assessment of relationship between law and morality. He said, 1, there is command. 2, there is dogma. And 3, there is precept. Command is, this is the law, you have to obey. Dogma, you are obeying because it is logical, it is reasonable, it appears to you, oh, yes, I think this law must actually be obeyed. And the third one is, this law is good, we must obey it. And that command is law. Precept is morality. In between the two is dogma, because it's talking about reasoning. And I said, what is good does not necessarily mean that it is good for everybody and therefore should be the rule of morality. What we see in one community or one society may not necessarily be immoral in the other. And it's happening now. Today, we have nude travels. That is, I want to go to supermarket where I can shop without wearing anything. I want to travel by plane where I don't have to wear anything on me. It's my choice. It is good for me. Whereas the new travels is not available for everybody. People that will say, no, how can I now go travel naked? To do what? To achieve what good? How can I go and shop naked? But that is good for some people, while it is not good for others. So the point we are making is that the division that Kantorowicz has created is a blood division, because these things do not just add up in real life and the way law and morality operates in the society. And that's why I came up with these examples: new travels, new supermarket. As far as Kantorowicz is concerned, it does not appear to reason to say people should go out without wearing anything. Whereas, as far as they are concerned, it's their right to decide to walk naked, and it's nobody's business to call attention to it or to say or to legislate against it. And if you now put such laws in place that people should not walk naked, of course, people are walking naked everywhere, including Nigeria. Go to campus, you will see people walk naked. In spite of, when I talk about naked, I am saying it deliberately and calling attention to campus, because when somebody puts on is it sleeveless, or what do you call it? The one that our ladies wear, teolapa.
Armless.
Armless, thank you. So to an average mullah and a malam, you are walking naked. To somebody that is in town,
so socialite.
God bless you. So essentially, what is one man's meat is another man's poison. So you cannot come up with, the law is good, and therefore we are obeying it. It is a law of moral, is a rule of morality. Oh, the law has been put in place, you have to obey it. It is therefore a rule of law, and that is a distinction between the two. And what we think is logical is also a question of who is actually assessing it and how reasonable is the individual that we are talking about. And of course, and we have also learned in our thought that the concept of a reasonable man is a nebulous concept, because reasonability, a reasonable man is not 1, 2, 3, 4, 5 features that we will have to identify him or her with. Are we together?
Yes, sir.
Okay, now.
Yes, sir. Thank you.
Okay. There's also a variant now. That's okay. Are we talking about law and morality? Is morality and ethics the same thing? Somebody is disturbing us. Agbede Idris. You are disturbing us. You are disturbing us. So the areas that they have come up with are: one, law devoid of morality is no law, is that an ethical position, or just talking about relationship between law and morality? Talking about evolution and revolution, is it also a question of discussing law and morality, or something that we're talking about ethics? And of course, there is the unscalcing denomination of law as it is and law as it ought to be, as another way of categorizing law and morality. That, oh, law as it is actually law, and law as it ought to be is morality. Well, these are far-reaching conclusions by some scholars, which I believe needs to be looked at in a more critical perspective. And I have also attempted to appraise the Atiku Abubakar case from the perspective of morality and the position of the law in an article I call Single Presidency in Nigeria, When Can VP Act? You may wish to see the Juris volume 15. It's just a short article, about 10 pages. The Jurist volume 15, pages 200 to 210. Now, talking about
Sir, please, sir, can you tell us the title again? You said Single Presidency in Nigeria.
When can Vice President act?
Thank you, sir.
Now, we talked about evolution and revolution, and I called attention to decrease. And that if it is put forward, we are still trying to do an analysis of Kantorowicz classification. And the question I have asked is, go back to Decree 4 of 1984. As far as Kantorowicz is concerned, Decree 4 of 1984 is a command, and it has to be obeyed the way it is put forward. And one curious provision in that decree, I think section 2 thereof, is that even if you say the truth, for as long as it is embarrassing to government, it will be an offense under Decree 4. And of course, that was why the two Guardian columnists or reporters were prosecuted, that even if it was the truth, it was. Now, the question now is it morally right? And can we be talking about the moral rightness of a law? That's the question that we need to now answer. Do we need to talk about the moral rightness of any law, especially in the light of the classification by Kantorowicz? Yes, can we have somebody to?
Hello, sir.
Not you. I want somebody else. Alima. We are not hearing you.
Can you begin with the question, sir?
I said I just gave a position on Decree 4 of 1984. I'm now asking the question, is it morally right? I mean, should there be any basis for moral rightness of a law before we say it is a law?
In my opinion, yes, it is.
Mm-hmm.
There should be a requirement of morality before you can actually say a law is effective.
Okay,
because
why?
if the law is made and it is not moral, it will not be effective, because for a law to, there's this term, to have effect in a society. No, that's not the correct term. If it is made, despite the fact that it is not moral, it will just be there. It will not actually work. Even if it does for a while, it will only be as long as the government that made it is in power, even if it works. But ordinarily it won't. So the decree, even though it's now, as we can see, it is no longer effective. If it were a law that had basis in morality, it would persist, even after the government that made it is gone. But that decree is not moral. It is totalitarian, in fact, a bit cruel. That's my opinion.
Okay,
Oh,
that's
sir.
a
Good
view.
morning, sir. Good morning,
Yes,
sir.
yes.
Oh, my name is Isaac Aziz.
Isaac Aziz, yes, I can see.
My stand is that sometimes, like for we to determine what is moral and what is right, it's like it can be determined by one's perspective. Because, let's say for an example now, when a lawyer says that his client is guilty to the court, it is like it can be moral for a lawyer to tell the court that his client is guilty of the offense he has been charged, but it is unethical on his part because there are standards of rules that forbids it hard. So what is moral, what is right, it depends on how we how we look on our perspective. Because if I say that the decree is morally wrong now, the people that make the decree will see it to be right in their own perspective. So in that regard, what is moral, what is right, what is ethical, what is unethical, depends on how we view it.
Thank you, Aziz. Any
Okay,
other
sir.
view?
Okay, sir. Good morning. Good morning, sir.
Good morning.
Yes, sir. I'm Abdulaziz.
Your name is not showing.
Yes, I'm Abdulaziz.
So when you are joining
Abdul
class next time, you should try to join with a device that will show us your name. Okay, go ahead.
All right, sir. Thank you very much, sir. Yes, sir. I actually feel the spirit of every law must always reflect morality, but should never be mixed together. In the sense that a stream of a law which channel along with the same part of a stream of a law which channel along with the same part of morality should always come up with a belief that the law and morality can never be mixed and can never be met and can never be mixed together.
Good morning, sir.
Good morning.
Good morning, sir.
Now, I would like to say that
That's
when it comes,
Ubanji Precious.
yes, sir. Only I would like to say that okay, well, before now, maybe last week, I would have said some of the things they were saying, but after Dr. Azuz's class last week, where he taught us about lawfare, we've come to understand that
Afterwards,
a class with Dr. Azubike that he taught us lawfare, like
lawfare.
Yes, how the government try to fight the people with laws, how they try to like, okay, so it was making an example of where a president's country, after doing his own electoral campaign, now made a law that there must not be any gathering of more than 20 people, and that day was supposed to be his opponent's campaign. And when his opponent went forward to do his own campaign, he was arrested, and then was arrested for disobeying the law of the country, and then was arrested and all that. So a lot of times laws are made not because they follow the perspective of morality, but for selfish interest from the leaders or whoever is making the laws. So they can just want to hide it under the term of morality. Because even if you look at the suspension of Twitter or Twitter ban now, that law, it appears to a lot of people that it was made because people are spreading fake news and all. But if you look at it, it's a warfare because a lot of a lot of things are being exposed through the social media and is even getting out to other countries, and people are really seeing the truth. So, in a stance, with this knowledge, I would like to say that more than morality, laws are made for selfish interest, and it's almost becoming more of a lawfare. So, a lot of times, laws are made to hide behind morality, but they are not really moral.
Well, while I am still to come to terms with lawfare, I cannot claim to have any form of knowledge apart from the way you are expressing it. But I think we are mixing something in the sense that we as students of jurisprudence, we must be quick to condemn the kind of arrangement that I will campaign today, and tomorrow I will make a law that my opponents cannot campaign. It can only happen in an underdeveloped society. It's just like the way Donald Trump wanted to rule America. It is only where institutions do not exist. And don't forget, one of our what do I say now? One of the things we agreed to in the course of our class in the past is that what we need are good institutions, not necessarily superhuman or super laws. And where we have institutions that are supposed to make laws, such a warfare will not happen if the institutions are respected and are in place. So for me, these are just aberrations in societies that are not as coordinated, as organized, and as developed as we will expect societies to be. So whilst I get your argument as emphasizing the fact that a law do not necessarily have to have any moral basis before it becomes law. Of course, that's what Kantorowicz is actually saying. There are different things. It may be a bad law, but it is put forward, you have to obey. So that's a view by Precious.
Yes, sir.
Yes.
Okay, I wanted to comment about your question.
Yes, go ahead.
Okay, because you're asking in view of the classification of Kantorowicz.
Yes.
If you go back to the first one you mentioned command. I think command has nothing to do with moral rightness. Like, we don't look at moral rightness.
I don't know.
Favor Samuel, you are disturbing us. Favor Samuel, you are disturbing us. Uzinat, you can continue.
Okay, so I said that like the first classification, command, like we don't look at moral rightness. It's just a command. For instance, the Electoral Act that you said that, for instance, you are not up to 18, you cannot vote. I think in some communities, they'll tell you that it is not moral because a 16-year-old person can be matured and all like that. So they just make the law as a command and they don't look at the moral rightness. So we can see it in that view of the classification of, what's his name? Kantorowicz. That's what I'm about to say.
Thank you. Abroshid, I will come back to, who is this?
Azusa. Yes, sir. Yes, sir.
Yes.
Okay, good morning, sir. So we already rightly posited that morality is actually based on perspectives and it is subjective. So now asking if there should be any basis of moral rightness for a law before we can say a law is a law. If you look at the instance of the decree, I feel like to people that has an authoritarian view of things, especially the government at that period, such a decree will be morally right to them, like it hinges on morality to them. But to we the masses that bear the brunt of such
legislations, to us it would be wrong. So I feel when we talk about morality, can we take it from the perspective of probably the majority and the minority? What the majority see as a moral rightness should actually, the law should have a basis of what the majority see as a moral rightness for the law to be a law, because basically we always have a fraction of people that would see a position as being moral and the other faction will see a position as being immoral. So I'm trying to bring a view that probably we should see whether law should be, there should be basis of probably majority morality for a law to be a law, because if the majority agrees to it, then it should definitely hold sway in a society. Like many people would be more inclined to go with whatever the law says at that point.
I want to assume that the way we can only determine majority will be as reflected in our representation at the legislative arm.
Yeah,
I can see that. Yeah.
But sir, I think when there are some procedures that are usually taken in place when the legislative arm of government wants to make law, there are things we have like opinion polls, and even at the different stages of reading of bill, there's a particular stage, I've forgotten the name of the stage, where people from stakeholders are usually called to say their own view and opinion about a particular bill that is on the that's in the house. So I feel like in any society that works, any working society and with working institutions, I feel like even though we have people as representative, opinions of citizens should also be used, like in form of opinion polls and things like that. So through that way we can know what the majority probably wants, and that's maybe where the law can come from and stuff.
Of course, that's what we do in Nigeria, because there's always a public hearing before a law is eventually passed. I can see some hands up: Abdurrashid, Alawiye, Linda, Theophilus, and one iPhone, in that order.
Okay, sir. Thank you very much, sir. If we continue to look at this definition or these rules given by Kantorowicz, without considering what jurisprudence is, maybe we will not be able to get it right. Now, looking at the definition of jurisprudence as posited by John Austin, he said that it is a philosophy which has to do with positive, general, and particular laws. Now, for positive, of course, we can relate that with the command theory brought forward by Kantorowicz in looking at the distinction between law and morality. Now, if we also look at it, laws can as well be general in terms of, okay, these are the rules that are made for everybody. But if laws are particular, we will not be talking about distinguishing between law and morality, because they will be working hand in hand in that regard. So my view is just that if we can, as much as possible, make laws in such a way that it will appeal to a certain society the way their standards are, then we won't be having a problem of trying to distinguish between law and morality.
Thank you. Alawiye.
So with regards to this issue, I'm having the opinion that it depends on the type of the society. If we are under, for instance, what you said under the issue of evolution and revolution, I think it is close to your opinion in evolution and revolution. If we are in the society whereby we need the opinion of people, I mean democratic society, I think law and morality and law we must go together. But if we are in the society whereby it is military, where they won't need opinion of people, whereby they have the absolute power to make any law they want, so we won't need to question. We won't be able to question the morality, even if we want to question it. Law cannot go with morality in such society. That's my opinion.
Thank you. Linda. Linda Daramola. Linda.
Good morning, sir.
Good morning.
Yes, sir. Answering the question of do we need to talk about moral rightness when it comes to the law? I actually feel like there is no need because everyone, when they want to make a law, has a moral justification in themselves, in quotes, as to whether or not the law is going to be good. Now, if we are going to put in consideration everyone's moral view and justification, then we will not be able to make any law because this view of this scholar that we just talked about is trying to, he made that view thinking that there is a uniform or accepted moral stand in the society. And if we do not have that kind of uniform accepted stand, then what will be deemed precept to some people that will make them obey a law will not be precept to some people. And what will be deemed dogma by some people will not be dogma by some people. So at the end of the day, the only thing people would obey will be command by virtue of the fact that they need to obey it, not by virtue of the fact that it is a dogma that seems reasonable or a precept that seems good. So I feel like moral rightness can never be a justification for what should be law and what should not be law in the society.
Thank you. Fantastic. Silas.
Yes, sir. Similar to Linda. Linda listed a very large chunk of what I want.
Sorry, oh. We are not hearing you, Mr. Silas. Well, sorry, Silas. Can we have the man with iPhone? We are not hearing you. We are not hearing you. We are not hearing you.
Good morning, sir.
Good morning.
Sir, I feel, sir, what is moral in some communities is not moral in some other communities. In the northern parts, for Nigeria, for example, now, sir, in the northern part, an average woman of 15 years old that she's married is considered an adult. While in the southern part, she's considered an underage. So the privileges she gets being an adult in the northern part, the human rights activists are against it, that she's still an underage and all. So there are contrary opinions as to the morality that comes with that and all. And Nigeria, for example, most of our head of states have been northerners. So human rights activists have not been able to talk more on that. And their position is limited because most of the people making the laws are northerners. The key people making the laws are northerners. So we can't fight for what is morally right there in that instance.
Yes, sir.
Yes.
Whether morality should be considered or should be a criteria for us for the validity of a law. So my own perspective is that although morality and law are interwoven, but the two, they do not coexist. They exist separately. So the fact that law seeks to ensure or safeguards the moral value of the society does not mean the purpose or the main purpose of law is to uphold morals. So there are a lot of laws that have been put in place. And
I'm not hearing you.
can you hear me now? Yes, sir. I think the network is bad.
Cranky.
Yes, sir.
We are not here.
Yes, sir.
Let's just take it that from the two views, I mean, from views expressed so far, that rule of morality as important as it is. Are you hearing me?
Yes, sir.
Yes, sir.
Yes, sir, I can hear you.
Are you hearing me?
Yes, sir.
Hello, you are hearing me?
Yes, sir, we can hear you, sir.
Okay. I said so far what we need to take away. It has its own way of influencing the law. But because morality, what I said, it may not be easy to general rule. Oh, morality. Because, but before we leave this, we
Sir, we can't hear you.
Sir, we can't hear you.
Sir, we can't hear
That's
you.
what is breaking.
also approaches. Hello, Rad Broch, R-A-D.
Sir, we haven't been hearing you for like 5 minutes.
B-R-U-C-H.
Sir, we
It came
can't
up
hear you.
with,
Sir, we can't hear you at
I have
all.
not talked for 5
Sir,
minutes.
we've not been hearing you since
Sir,
we
we've not been
started.
hearing you.
The only thing we heard was morality has its own way in influencing the law, but
Influencing the
we
law.
didn't hear after that time.
Now, Uncle. Eh?
We
We can
can
hear
now.
you.
You now,
We
sir.
can hear you now, sir.
Are you hearing me now?
Yes, sir.
Eh?
Yes, sir.
Yes,
Yes,
sir.
sir, we can hear you now.
Okay. I said when we talk about morality as is for law, we will that because moral standards differ from one community to another, and that what is important is that the society will design the laws that it has a moral basis or not is a society of
Sir, the service is breaking.
morality in the so that we should
I can't hear
consider
you.
Rad
Sir, we can't hear you.
Broch.
Sir, we can't hear you,
Sir, the
sir.
network is bad.
Hello,
Sir, the network was very bad.
are you hearing now?
Yes,
Yes, we
sir.
can.
Are you hearing now? Eh?
It's still breaking, sir.
It's still breaking.
It's still breaking.
It's still breaking, sir.
Still breaking. What can I do now? Eh?
Change your direction, sir.
Okay. Oh, I should change my network.
There can be network in other parts of the room, sir.
Rabbi.
Let me see.
I think you should continue, sir.
Huh?
I'm thinking you should continue, then maybe just repeat each time, anytime your attention is brought to it.
Is it better? Is it better now?
No, sir.
Worse, sir. It's even worse.
Recording in progress.
I'm trying to join them.
Hello? Is it better?
It's much
Yes,
better
sir.
now.
Yes, sir. Yes, sir.
Let's be hopeful that it will remain better. What I just want to ensure that this other device is not interfering. So as I was saying, that the there was this position by Radbruch, Radbruch, who came up with what he called fundamental principles of humanitarian morality. And the bottom line is he wants to create a general standard. We just discussed that where society will determine what kind of, how much of morality it will inject into its undertakings. And that will be determined by one, the standard in the society, and two, the individuals constituting the society. But what Radbruch tried to do is to create a general standard, which he called humanitarian morality. What Radbruch tried to preach is that no law without morality, because goodness is the basis of the law. And that what he believes is humanitarian morality is something that, adultery is bad. It is bad for everybody. Homosexuality is bad. It is bad for everybody. Lesbianism is bad. It's bad for everybody. But that society never exists. And no society that will have that basis. Because even in societies where the moral standard is left at the highest, there will still be deviants whose moral standing will diminish more than that of
the society. I hope we are together. Hello?
Yes, sir. Yes, sir.
We are together.
Fine. So if that is the situation, that we would have had a Nazi Germany experience. We are not likely to have the kind of regime that we had in Abacha. We are not likely to have had apartheid in South Africa if the postulation by Radford is anything to go by, that there will be the same standard of morality for everybody. It never exists. That cannot happen. Now, a development on Radbruch is another view expressed by Professor Hart, H-A-R-T. That's the opposite direction now. Radbruch is talking about fundamental humanitarian morality. Professor Hart is saying, even if a law is wicked or is put in place to perpetuate wickedness, you cannot disobey it because they are not less law. So the point Hart is making is that even if a law is devoid of morality, it is still the law. As against Radbruch, who is providing a benchmark for every society, and which every society must ordinarily be live with, as it were. Are we together?
Yes, sir.
Fine. A development had, however, come into place with regards to law and morality, and that is what they now call private and public morality. That is, there are some morality that are private to the individuals, and we should not be talking about such as affecting our laws. Only the issues of public morality should affect our laws. By private morality, it says, oh, homosexuality, lesbianism is a private affair. Drug addiction is a private affair. That's nothing to do. It has nothing to do with the public. So if you engage in such private immorality, that's your business. Unfortunately, there cannot be any such division as strict as the protagonist wants us to believe that, oh, it is private morality, is their business. It is only public morality that will have effect. But unfortunately, there cannot be public morality without private morality. That are affecting public.
The service is breaking.
Morality. For us, the distinction. Hello? Hello?
Sir, we didn't hear you. The service was bad.
Are you hearing now?
Yes, sir.
Yes, sir. You said that there can't be public morality without private morality. I think that was where the service got bad.
Yes. And with that position, what it means is that we cannot create that division of private and public morality. For instance, the argument is that lesbianism is private morality, homosexuality is private morality, drug addiction is private morality, forgetting that at the end of the day, if these private people commit themselves to some things, it will eventually have effect on the society. Even when you think, oh, you don't have to bother about us, it is our life, we can live it the way we want, and you go into drug addiction, forgetting that the public health will eventually be affected if they continue with what they call private morality. For instance, somebody that is a drug addict or somebody that is an alcoholic, if he drives and has accidents, somebody else is already affected by his drunk driving situation. So that's why we believe that that division is not right. Are we together?
Yes, sir.
Yes, sir.
The next issue with regards to law and morality is morality, law, and human rights. Today, the blood division between law and morality is actually aggravated by the human rights activists. You will recall I called attention to new travels, I called attention to new supermarkets before. Those are quote unquote moral issues, but which has serious impact on the legal regime. But as far as the human rights activists are concerned, law should not bother itself about the morality of the individuals in the society, because the individuals in society have human rights to do whatever they need to do. So you cannot legislate against such things that you think are immoral. If two adults decide to marry themselves of the same sex, if two adults decide to have fun with themselves, what is the business of the society legislating against that? But we must emphasize that the peculiarity of each society will actually determine what law should be put in place based on our environment. Do you have questions? Do you have questions?
No.
Me, I have a question. Oh, this
Yes, go ahead.
public and private division of morality, who is the proponent?
No, essentially, it was based on the Wolfenden report on homosexuality and prostitution.
What?
Wolfenden, WOLFENDEN report on homosexuality and prostitution. And the liberalist school of thought also.
Sir, sorry, we didn't get that. Sorry, sir.
I said Wolfenden report. You should have come across Wolfenden report in your criminal law. Wolfenden report on homosexuality and prostitution. Your concern in criminal law is whether that report was right in coming to terms with prostitution and homosexuality. Those are reports that condemned, I think it was in 1961 or so, that condemned homosexuality and prostitution. Today, the same society that put up Wolfenden report, commission that came up with the report, is now under human rights, eulogizing homosexuality and prostitution. I hope you get the point I'm making.
Mm-hmm. Yes, sir.
We came up with the fact that standard of morality differs from one community to another, from one society to another, from one environment to another. And now it is clear that even from that time is also important on what could be regarded as moral principles. If you go back to Wolfenden report, it condemned prostitution, it condemned homosexuality. It was in England. Today, in UK, homosexuality is allowed. prostitution is practically allowed because it's a human right thing. I hope we are together.
Yes, sir.
Yes, sir.
Yes, sir.
Okay, fine.
Yes, sir.
So, good.
Yes,
Now,
sir.
you may wish to read, I think I gave you the last time, Inextricability of Law and Morality and Appraisal of Nigerian Legal System in the Juris Volume 8.
Sir, can you please come again?
Inextricability of Law and Morality and Appraisal of Nigerian Legal System. It was written by Hosseini Umar in the Juris Volume 8, pages 111 to 129. You may also check out the following cases. Let me see if I can send it on. Professor Etudaye. Professor Etudaye. I want to assume my slide has been shared with the class, Abi.
It's been shared, sir.
So there's no point. I will just mention the stocks. So go back to it, gentlemen. Ezelgo and Oyanere, 1978, 6 to 7 IC 1. Onya and Onya, 1989, 1 Nigerian Credit Law Report Part 199514. Mabuja Anambra Imo River Basin Authority, 2006, 14 Nigerian Credit Law Report Part 1000,691. Udosen and the State, 2007, 4 Nigerian Credit Law Report Part 1023. And Pojo Automobile Nigeria versus OJ, 1997, 11 Nigerian Part 530. For me, I want to assume that we need to read these cases to be able to appreciate the way the Nigerian courts have viewed the matrix between law and morality. Can we continue?
Yes, sir.
Good.
Yes, sir.
We must appreciate the fact that the relationship between law and morality is systematizing. Systematizing in the sense that I've come up with a Wolfenden report. At a point, it was right. At another point, it was wrong. So the relationship between law and morality is systematizing. That is, it will determine what is right and what is wrong. But what is right and what is wrong is a function of a number of factors. 1, time. 2, environment. 3, individual. I hope we are together.
Yes, sir. Please repeat that, sir.
Yes, sir.
I said the relationship between law and morality is systematizing. That is about system. And the system is right and wrong. But right and wrong is also a function of the individuals, the society in which the individual lives, and the time in which the act is being considered. I go back to the Wolfenden report, which condemned homosexuality and prostitution at the time. That same society now does not see prostitution, homosexuality as a moral problem again. But in dovetailing between law and morality, I call attention to ethics. And it is about duties that we have as lawyers. It's about duty that we should have as students of jurisprudence that has discussed law and morality, a division of which is ethics. ethics and morality is interchangeably used. But ethics is more of the kind of behavior that are standard, that are expected in group or in society. That is, it is not as large as morality. I have told you the systematization of morality: right, wrong, time, community, individual. But the difference is that ethics is about essentially the individual in a community, and is like a code of behavior, what you cannot do or must not do if you belong to us. That's the difference between law and morality and law and ethics. For instance, in the legal profession, there is the rule of confidentiality as part of our ethics. That is, as a lawyer, you cannot and must not breach the confidence of your client. As part of the ethics, you are also expected to be a minister in the temple of justice. Why you are, why you are not expected to breach the confidence of your client, you have your duty to court as a minister in that temple. So your ethical standard will have to be benchmarked between your duty to the court and to the profession eventually, as well as the duty to your client. There's also the rule on integrity. That is, everything that you do as a lawyer is in the duvet of integrity. It has to be wrapped with integrity. And of course, there's the rule of respect for the profession and your colleague and the society. In ensuring, I'm talking about the legal professional, in ensuring that the ethics of the profession prevails, they came up with the Legal Practitioner Disciplinary Committee to ensure that anybody that breaches the ethical rules will face the LPDC, Legal Practitioner Disciplinary Committee. But if you look at the decisions of Legal Practitioner Disciplinary Committee over the last 5-10 years, some certain trends have come up. One, there is the caretaker syndrome. That is, most things that takes people before the Legal Practitioner Disciplinary Committee are those that involve themselves in caretaker business. And to that extent, it has seriously affected the growth of the profession. Two, there's also the problem of economic recession, which has also affected the growth of the profession. But we must ask ourselves, one, how many legal practitioners that breaches the ethical rules are taken before the Legal Practitioner Disciplinary Committee? One. Two, how effective are the decisions of the Legal Practitioner Disciplinary Committee? These are issues that we may on our own try to interrogate. Do we have questions?
No, sir.
Now, the next in terms of ethics is, what are those to inject into our ethical values? as 21st century lawyers. These are things that we should continue to reflect upon, to agitate our minds on, and see whether our going to the profession will improve it or diminish it. Yes, do you have questions? If you don't have, we will close today, and hopefully we'll call next for the next class to start another topic, essentially.
Thank you very much, sir.
You're welcome. So no questions. Hello?
None, sir.
No questions, sir.
None, sir.
No, I have a question.
No
I have a
question. No
Thank you, sir.
question.
Somebody said
Amina
they
is
have
having a question. Amina, talk.
Sir, the part that we were talking about, I didn't really get the part. We were talking about law, morality, and humanitarian something. We were talking about what human rights, like activity, is it law or morality to be? So I didn't really get that part. The part after private and public, what private and public morality is, I didn't really get that part before you started giving us cases.
Yes, what we are saying is that today, the human rights regime in the globally has created an entirely different basis for assessing morality, because what we think is immoral in a society is now something that human rights activists believe is limiting their rights. For instance, I have a right to shop nude. I have a right to travel nude. I have a right to engage in homosexuality. I have a right to be a lesbian. I have a right to prostitution. That is an economic engagement. So it's my fundamental right to have a life and a livelihood. To that extent, what we think are immoral, quote unquote, can no longer be basis for our laws, because there is law. There was at the time law against prostitution in many developed economies. But today, these laws are no longer valid because the basis of coming to such laws was the moral standard at the time in the environment. But the moral standard has changed in such a way that these individuals that are regarded as deviants and are supposed to be punished are no longer the deviants because the society has permitted it, because of the development in the human rights enclave. I hope it's clear now. Amina?
Yes, sir.
Okay, and
Thank
everybody, I guess. Okay. So, Professor Tudaye, any comments, contribution?
None, sir.
Okay. So, gentlemen, have a wonderful week ahead. The way to start the week. So, thank you so very much.
Thank you, sir. Thank you, too,
Thank you, sir. Thank you, sir. You're welcome.
You're welcome. You're welcome.
Thank you, sir.
Bye-bye.
Thank you, sir.
Thank you.